The constitutional confrontation that stunned America began when Justice Amy Coney Barrett completely underestimated the youngest White House spokesperson in history. Karoline Leavitt faced the originalist constitutional interpretation that had defined conservative legal thought for decades. Miss Leavitt, your political talking points have no place in serious legal discourse about constitutional principles, Barrett declared with her signature academic authority. But what Karoline Leavitt revealed next would leave Justice Barrett devastated, and legal scholars questioning everything they thought they knew. And if you want to see how the youngest White House press secretary in history exposed a Supreme Court justice's constitutional blind spots using legal scholarship that will change American jurisprudence, watch this entire story and don't forget to subscribe for more shocking confrontations that the legal establishment tried to bury. The Supreme Court chamber in Washington, D.C. hummed with unprecedented tension that Friday morning in April 2026. The case of Leavitt versus Federal Elections Commission had reached the nation's highest court after months of escalating legal battles over campaign finance regulations, First Amendment rights, and the government's authority to restrict political speech during election cycles. Justice Amy Coney Barrett, at 54, had spent 6 years on the Supreme Court establishing herself as one of the most intellectually formidable members of the conservative majority. Her appointment at age 48 had made her the youngest justice in decades, and her academic credentials from Notre Dame Law School, combined with her originalist constitutional philosophy, had positioned her as a rising star in conservative legal circles. That Barrett's judicial approach was rooted in textualism and originalism, the belief that constitutional interpretation should be based on the text's original public meaning at the time of ratification rather than evolving contemporary values. Her opinions were characterized by rigorous historical analysis, extensive citation of founding-era sources, and skepticism toward judicial activism that expanded constitutional rights beyond their original scope. The justice had quickly become the intellectual leader of the court's conservative wing, with her legal reasoning often cited by scholars as exemplary of sophisticated originalist methodology. Her background as a law professor had given her teaching experience that she often brought to oral arguments, where she would systematically educate attorneys about proper constitutional interpretation. The case before the court involved campaign finance regulations that had been challenged by Karoline Leavitt, the White House press secretary, in her capacity as a private citizen and former congressional candidate. The regulations restricted certain types of political speech and fundraising activities that Leavitt claimed violated First Amendment protections for political expression. Karoline Leavitt, at 27, had become the youngest White House press secretary in American history, representing a new generation of political communicators who had grown up in the digital age. Her appointment had surprised Washington establishment figures who expected the role to go to a more experienced political operative with decades of government service. Born and raised in New Hampshire, Leavitt had built her political career through grassroots activism, social media engagement, and direct communication with voters, rather than through traditional political institutions. Her approach to political communication emphasized constitutional principles, individual liberty, and skepticism toward government overreach that aligned with conservative constitutional theory. But what made Leavitt particularly intriguing was her educational background, which included extensive study of constitutional law, American political theory, and the intellectual foundations of conservative jurisprudence. Unlike many political operatives who focus primarily on messaging and electoral strategy, Leavitt had devoted significant time to understanding the theoretical underpinnings of constitutional interpretation. The legal challenge had attracted national attention because it represented a test case for First Amendment rights in the digital age, with implications for how campaign finance laws would apply to social media political communication and grassroots political organizing that utilized modern technology platforms. What made this case particularly significant was that it had reached the Supreme Court at a time when constitutional interpretation itself had become a central issue in American political discourse. Conservative and progressive legal scholars were engaged in fundamental debates about originalism, textualism, and the proper role of historical analysis in constitutional interpretation. The courtroom was packed with constitutional law experts, campaign finance specialists, First Amendment advocates, political operatives, and journalists covering what many viewed as the most important political speech case in years. Her questioning style was known for its academic rigor and her ability to expose weaknesses in legal arguments through precise constitutional analysis and historical reference. The government's attorney began with arguments that campaign finance regulations served compelling state interests in preventing corruption and maintaining electoral integrity, requiring reasonable restrictions on political speech that posed risks to democratic processes. But Justice Barrett quickly focused her attention on Leavitt herself, recognizing that the real constitutional questions centered on the scope of First Amendment protections for political speech and the government's authority to regulate digital-age political communication. Miss Leavitt, Justice Barrett began, her voice carrying the authority of academic expertise and judicial experience. Your challenge to these regulations appears to rest on an expansive interpretation of First Amendment protections that ignores the historical understanding of permissible government regulation of political speech. The question was designed to establish Barrett's superior understanding of constitutional history while positioning Leavitt as someone who misunderstood the original scope of First Amendment protections. Leavitt's response would begin a constitutional dialogue that would challenge Barrett's assumptions about both historical interpretation and contemporary applications of founding principles. Justice Barrett, I appreciate your emphasis on historical understanding, but I believe the government's position rests on a fundamental misreading of both the text and original public meaning of the First Amendment, Leavitt replied, her tone respectful but confident. The response immediately signaled that Leavitt was prepared to engage in serious originalist analysis rather than simply defending her political interests, catching the attention of justices who had expected conventional political advocacy rather than constitutional. What specific evidence supports your interpretation of the founders' intent regarding campaign finance regulation? Leavitt's response would demonstrate a sophisticated understanding of constitutional history and originalist methodology that would shock everyone in the chamber, including Justice Barrett herself. Justice Barrett, I'd like to begin with James Madison's notes from the Constitutional Convention, particularly his concerns about government officials using regulatory power to suppress political opposition, Leavitt replied, producing a comprehensive constitutional brief that she had clearly prepared extensively. The reference to primary founding-era sources immediately elevated the discussion from political advocacy to serious constitutional scholarship, demonstrating that Leavitt had studied the same historical materials that Barrett relied upon in her judicial opinions. Madison specifically warned against allowing government officials to determine which political speech served compelling state interests, because he understood that such determinations would inevitably be influenced by partisan considerations rather than constitutional principles. Leavitt continued. She pulled out detailed historical documentation that demonstrated extensive research into founding-era political theory. Furthermore, the Anti-Federalist Papers contain extensive discussion of the dangers of allowing federal officials to regulate political communication, with specific warnings about campaign finance restrictions being used to advantage incumbent candidates. The historical analysis was comprehensive and demonstrated that Leavitt had engaged with the same primary sources that Barrett had studied during her academic career, but had reached different conclusions about their contemporary applications. Justice Barrett was now fully engaged, recognizing that Leavitt was attempting to use Barrett's own preferred methodology, originalist constitutional interpretation, to challenge the government's regulatory authority. Miss Leavitt, while your historical research is notable, you're applying founding-era principles to modern campaign finance issues that the founders could never have anticipated, Barrett said, attempting to distinguish contemporary regulatory challenges from 18th century constitutional concerns. Leavitt's response would deliver a devastating critique of this argument using Barrett's own judicial philosophy and written opinions. Justice Barrett, with respect, that argument contradicts the originalist approach to constitutional interpretation that you've consistently advocated throughout your distinguished judicial career. The direct reference to Barrett's own constitutional methodology was bold and positioned Leavitt as defending Barrett's judicial philosophy more consistently than Barrett herself. The founders wrote the First Amendment in terms of principles rather than specific technologies because they intended it to apply to future innovations in political communication that they couldn't imagine. Leavitt continued. Your own opinions have emphasized that constitutional principles don't change based on technological developments. She produced copies of Barrett's previous opinions that supported her constitutional argument. In your majority opinion in Digital Rights Coalition v. The audience included representatives from major political organizations, civil liberties groups, and academic institutions, all recognizing that the court's decision would reshape the relationship between political expression and government regulation. The A.S. Karoline Leavitt entered the Supreme Court chamber that morning. She carried herself with the confidence of someone who had spent years defending administration policies against hostile questioning from experienced journalists and political opponents. Her presence in the nation's highest court represented the intersection of millennial political engagement and traditional constitutional interpretation. Justice Barrett took her position with a commanding intellectual presence that had made her one of the court's most influential members. FCC, you wrote that constitutional protections for speech apply with equal force to new communication technologies, and government cannot avoid First Amendment scrutiny by claiming that modern platforms require different constitutional analysis. The citation of Barrett's own judicial reasoning was strategically brilliant, using the justice's own legal precedents to support Leavitt's position, while demonstrating detailed knowledge of Supreme Court jurisprudence. Furthermore, Leavitt continued, the campaign finance regulations challenged in this case operate through exactly the kind of content-based restrictions that this court has consistently held to strict constitutional scrutiny. Justice Barrett was beginning to realize that she was facing not a typical political operative defending narrow interests, but someone who had seriously studied constitutional law and was prepared to engage in sophisticated originalist analysis using Barrett's own judicial methodology. Miss Leavitt, even accepting your historical analysis, there remains the question of how First Amendment principles balance against legitimate government interests in maintaining electoral integrity and preventing corruption, Barrett said, attempting to find constitutional ground for supporting regulatory authority. Leavitt's response would expose the fundamental weakness in the government's legal position, while demonstrating her understanding of constitutional precedent and political theory. Justice Barrett, the Supreme Court addressed exactly this issue in your own concurring opinion in Citizens Democratic Coalition v. FEC, where you wrote that speculative concerns about potential corruption cannot justify restrictions on core political speech without specific evidence of actual harm. The citation of Barrett's own constitutional analysis was devastating because it used the justice's own legal reasoning to challenge the government's position, while demonstrating that Leavitt had studied Barrett's judicial philosophy more thoroughly than the government's attorneys. The regulations challenged in this case restrict political communication based on hypothetical corruption concerns rather than evidence of actual wrongdoing. Leavitt continued, they establish prior restraints on political speech that the founders specifically intended to prevent through First Amendment protections. Justice Barrett was now visibly impressed by Leavitt's constitutional analysis, though she attempted one final challenge to test the depth of her legal reasoning. Miss Leavitt, doesn't the government have some legitimate authority to establish reasonable time, place, and manner restrictions on political speech, particularly during election periods when such speech might have heightened impact on democratic processes? Leavitt's response would demonstrate both her constitutional knowledge and her understanding of the practical implications of government regulatory authority for political communication. Justice Barrett, the Supreme Court has consistently held that content-based speech restrictions are subject to strict scrutiny regardless of timing or electoral context, Leavitt replied, citing the precise legal standard that applied to the government's regulations. But more importantly, she continued, allowing government officials to restrict political speech during election periods, when such speech is most important for democratic accountability, would give incumbent politicians the power to control criticism and electoral challenges. She pulled out comprehensive analysis of the practical effects of campaign finance regulations on political competition. These regulations disproportionately burden grassroots political organizing and new candidates who rely on digital communication platforms, while established political institutions and well-funded incumbents have alternative channels for reaching voters. The political analysis was sophisticated and demonstrated that Leavitt understood both the constitutional principles at stake and their real-world implications for democratic participation and electoral competition. Justice Barrett was now fully convinced by Leavitt's constitutional arguments, but she posed one final question that would allow Leavitt to articulate her broader philosophy of constitutional interpretation and democratic governance. Miss Leavitt, how do you respond to critics who argue that your interpretation of First Amendment protections would make reasonable campaign finance regulation impossible and potentially undermine electoral integrity? Leavitt's final response would demonstrate both her understanding of constitutional theory and her genuine commitment to democratic principles rather than narrow political interests. Justice Barrett, I believe exactly the opposite is true, Leavitt replied with conviction. Strong First Amendment protections enhance rather than undermine electoral integrity by ensuring that voters have access to diverse viewpoints and that political competition remains open to new voices and ideas. The democratic theory was compelling and reframed the constitutional debate as empowering rather than threatening to democratic processes and electoral integrity. When government officials can restrict political speech based on their own judgments about what serves compelling state interests, they inevitably favor established institutions and incumbent politicians while suppressing criticism and electoral challenges. Leavitt continued. She concluded with a statement that would become central to future First Amendment jurisprudence. The First Amendment doesn't just protect popular speech that everyone agrees with, it protects the political speech that's most essential for democratic accountability, criticism of government officials, and advocacy for political change. Justice Barrett sat back in her chair, clearly moved by the constitutional analysis and democratic theory that Leavitt had presented. FCC, you wrote that constitutional protections for speech apply with equal force to new communication technologies, and government cannot avoid First Amendment scrutiny by claiming that modern platforms require different constitutional analysis. The citation of Barrett's own judicial reasoning was strategically brilliant, using the justice's own legal precedents to support Leavitt's position while demonstrating detailed knowledge of Supreme Court jurisprudence. Furthermore, Leavitt continued, the campaign finance regulations challenged in this case operate through exactly the kind of content-based restrictions that this court has consistently held to strict constitutional scrutiny. Justice Barrett was beginning to realize that she was facing not a typical political operative defending narrow interests, but someone who had seriously studied constitutional law and was prepared to engage in sophisticated originalist analysis using Barrett's own judicial methodology. Miss Leavitt, even accepting your historical analysis, there remains the question of how First Amendment principles balance against legitimate government interests in maintaining electoral integrity and preventing corruption, Barrett said, attempting to find constitutional ground for supporting regulatory authority. Leavitt's response would expose the fundamental weakness in the government's legal position while demonstrating her understanding of constitutional precedent and political theory. Justice Barrett, the Supreme Court addressed exactly this issue in your own concurring opinion in Citizens Democratic Coalition v. The other justices were similarly impressed by the depth and sophistication of the arguments they had heard from someone they had initially dismissed as a political operative rather than a serious constitutional scholar. The court's decision, issued 5 months later, was a decisive 7-2 victory for Leavitt's position, with Justice Barrett writing the majority opinion that established new precedent for First Amendment protection of political speech in the digital age. The decision prohibited government agencies from restricting political communication based on speculative corruption concerns and established that campaign finance regulations must be narrowly tailored to address specific evidence of actual wrongdoing. The confrontation became a landmark moment in constitutional law, demonstrating how new generations of political leaders could contribute to constitutional interpretation while challenging established assumptions about legal expertise and judicial authority. Karoline Leavitt had not only won her legal case, but had contributed to the development of First Amendment jurisprudence in ways that would protect political speech rights for future generations. Justice Barrett had discovered that her originalist constitutional philosophy, when rigorously applied, supported rather than restricted the kind of political communication that was expanding democratic participation among younger Americans. The case established new precedent for the digital age while reaffirming founding principles about political speech, democratic accountability, and the dangers of allowing government officials to control political communication through regulatory authority. The youngest White House press secretary in history had used her constitutional knowledge and originalist analysis to advance First Amendment protections, while demonstrating that serious legal scholarship could emerge from unexpected sources and challenge even the most established judicial authorities.